welcome to the Law and Crime Network. My name is Bob Bianchi. I'll be with you at 3 o'clock. You know, if we're here at the Law and Crime Network, you know we have multiple live trials at any time. This is a Rolling Stone organization here, folks. No moss growing, you know, as far as we're concerned, because here's what I got to try to tell you to give you the updates with all the stuff that we're covering and why I love hosting on this network. In the Christopher Vasada case, they're calling still defense witnesses to the stand. So that case is still active, and we're going to be covering that case as well. As you know, we are covering the Scott Nelson case. They have a DNA expert that's on the stand right now, but the main trial we have been covering for most of today is the Wesley Mathews case, because it's been fiery and peppery, and we're going to have all the clips that are relevant in each of these trials crystallized down to the most important testimony, so you get the flavor of each one of those cases and how it is progressing. I got Gene Rossi with me. Gene, I want to finish up a little bit of what we were talking about on the Mathews case, because we had that hard break there, and we had to kind of cut you off a little bit. And so, again, each state is different, but to me, this slow plea was to give the benefit that the defendant won't be facing the death penalty. That's taken off the table, but he could be facing anywhere from probation to life based upon the various charges that were pled guilty to, but he did not plead guilty to a homicide charge. He pled guilty to an offense of omission and failure of taking care of the kid. So when I'm looking at it, like, that's the guilty plea. That's the guilt phase. That's what he's convicted of. But at the sentencing phase, which is where we are right now, the prosecution is outright accusing him of being the murderer. So it's almost like, to me, if I plead a client guilty, plead him guilty, and I go to the court for a typical sentencing like I do every day as a defense lawyer, I don't have to answer for all the charges in the indictment at sentencing. I only have to answer to the charge that was pled guilty to. What am I missing here?
You're missing nothing. If you've been charged with 10 counts, let's just say failure to file a tax return or tax evasion for 10 straight years, and you only plead to the last year, you can't say at sentencing that, hey, he should have pleaded guilty to the other 9, therefore you should sentence him even harsher. You're focused on that 1 year. And these are different crimes. One's an omission. It's basically failure to fulfill a duty to your child. The other is premeditation. It's intent. They are apples and oranges. It is improper.
And, you know, Gene, we talked about this, just so let's round this corner for one more time for our audience. It's being allowed to occur, and then to compound that issue as I see it, certainly this is what I would argue if I were the defendant on appeal, is the temerity, this is how I would argue, of the prosecutor to engage in plea negotiations on the witness stand and basically blaming the defendant for the jury having to listen to the evidence and see those photographs, which was a prosecutorial decision to show those photographs, and shift, if you will, burden shift, and basically attack him for exercising his constitutional right to a jury trial. When you add these things up, I'm thinking even in Texas, I mean no disrespect to the folks out there in Texas, but even with whatever kind of system you call it, where there's a lot of laxity given to prosecutors, we are in dangerous territory. Gene, my last point before you comment is, we say it all the time, and you didn't even need to do it with the evidence in the case. You went too far, in my opinion.
Yeah, I think he got a little greedy. I want to correct my comment about the taxes. If you have 10 counts that are all almost the same, that's different. You can bring that all out at sentencing. But here you have an omission versus premeditated murder. It's like, you know, you plead to theft, and then the prosecutor says, well, you really robbed the person. You can't do that. You can't do that if they haven't pleaded guilty. And I want to say this. If the prosecutor felt so strongly about the murder charge, then why the heck did they allow him to plead guilty?
Amen. Amen, brother. And so basically by doing that, they deprived the defendant of the value of when they entered into this negotiation. And the defense actually said that keep in mind, this is about an omission, not about a purposeful act. Anyway, the prosecutors, look, they did a good job on their feet in closings and in cross. I just worry about the constitutional parameters if they went too far. Okay, that was the first part of the prosecution's closing statement in the penalty phase. Guys, like I said, I love this network because you juggle so many balls between all these different cases that we're covering and great guests like Gene Rossi, and yet I got another ball to juggle with another unbelievable, amazing guest, Anne Bremner, former Deputy DA, Kings County Prosecutor's Office, specialty in sex crimes prosecutions and many other high-profile prosecutions in private practice, many high-profile defense cases, multiple media outlets as a legal analyst, multiple articles and awards. And like I like to say, if you want to know about Anne Bremner any further, read the 21 pages on Wikipedia about her career. It's quite impressive. Anne, welcome to the show.
Well, I'm thrilled to be on and honored to be on with both of you. You are luminaries and icons, so thank
wow,
you.
luminaries and icons.
Cut it out.
Let's hashtag that. Hey, listen, Anne, I want to come to you. I'm not sure if you had an opportunity to see the closings of the prosecution, but let me just put you up to speed. The prosecutor, first on cross-examination of the defendant, I was just discussing with Gene, was allowed to basically say to him, hey, listen, if you're so sad and upset about this, I'll offer you to take the life sentence right now. You made this jury go through looking at these photographs and all this horrible evidence, and if you feel so bad, this was a colloquy going on. Eventually there was an objection. It was sustained, but he essentially attacked the defendant for exercising his right to a trial. And then in closing statements, there were a number of comments that were made, essentially very similar to that, basically saying you should give him life instead of probation. There's this huge whole spectrum between probation and life. I don't know, did this go too far? I mean, he was a very effective, skilled cross-examiner and a very effective advocate. The chatters loved him. He was real good, but I'm just worried he went too far, Anne.
All right, and it's kind of, he'll be on the calendar, on the appellate calendar on prosecutorial misconduct day, maybe. I mean, there's a line, of course, and you're talking about evidence and putting it together, but, going that far, you're basically going to be in a position of, like, defending the redoubt on appeal and going, crossing that line. You want to cross it, but we know as prosecutors, when you're doing the right thing and just seeking justice, just gotta go over it. You can go close to it, but not over it.
Yeah, I'd really love to know a little bit about the history. I mean, I was always very proud as a prosecutor. I had a pretty significant trial success record, never reversed on appeal. Wow. I'm not saying that to pat myself on the back, but I am saying that when we train people, to me, it never made sense. And a lot of the things where prosecutors would just go over that line, a lot of times it had to do with commenting in some fashion on the right to remain silent, or maybe in this case, commenting on his right to have a jury trial, which is a constitutional right. Sometimes they just went too far and they tripped into a constitutional area. The case comes back and it's never good for the prosecution. Gene Rossi, you've seen this in your career. Why does this happen? Why are they not more centered and focused? And lastly, just because you can doesn't mean you necessarily should, Gene Rossi.
Well, I think you hit the nail on the head. Just because you can, you should not. But when you're doing your rebuttal, not so much closing, but oftentimes in rebuttal, the prosecutors go across the line because they know they're the last word. You get your adrenaline gets pumped, your heart's palpitating, you're trying to hit that home run and come up with that bromide and phrase that's going to just knock the jury over, and you just get excited. And I think he probably succumbed to that affliction. I gotta criticize the judge here. Even though the defense attorney was asleep at the switch and did not object, I got to tell you, I had judges, they would have jumped out of their chair and they would have corrected the record.
Yeah, that is an excellent point, Gene. And again, each state is a little bit different in their temperament as to what they're going to allow prosecutors to do or not. But when you're dealing with constitutional issues like we're talking about, I had said initially when he got up there in closing, and the chatters disagreed with me, which doesn't happen often, that I think he was taking things too personal in the beginning, and then he kind of rebounded. But I don't know. Then it kind of maybe went over that line. We'll see whether there's a line there in Texas with respect to those kind of comments. Nevertheless, it was very powerful. So let's listen to a little bit more of this is the prosecutor's closing statement in the penalty phase. Okay, let's keep in mind now, that was the first prosecutor, the female prosecutor you just saw there. The prosecutor we were talking about with regard to the other commentary was the one who went after the defense. They were allowed to have more time, the prosecution. That was the male prosecutor. Anne Bremner, so what happened here is this deal they've got out there in Texas called a slow plea. So it took it out of the death penalty. He pled to injury to a child by omission, and the sentencing can be, and I did a breakdown, we did, actually the Law and Crime Network did this for us, either intentionally, knowingly, recklessly, or with criminal negligence. So that's the whole span of like mental conduct you could get. Recklessly or negligently by omission causes a child serious bodily injury or bodily injury, and depending on where the jury is finding those facts, could be anywhere from a probation to a life sentence. Isn't it odd that the jury has to come up, and Kathy Rustin, one of our greats here at the Law and Crime Network, I asked her this question and she came up with the answer. They've got to come up with an exact number. I mean, what if you get somebody that says, I don't think it's probation, certainly, I don't think it's life, I think it's somewhere like 30 years, and somebody says, no, I think it's 25 years, no, I think it's 22.49 years. It could get squirrely. I don't think that's going to happen, but it could, right, Anne Bremner?
Right, except for I guess you kind of look at civil cases where you've got numbers and they have to basically compromise and say, I think $2 million, and someone else says, I think $1.
Yeah.
But it's so weird to have that kind of a phase with the jury on sentencing, and it's not a death case, and for them to come up with a number.
Yeah, that is a good point. They do that, and what Ann is saying is that, they have to, at least in Jersey, again, every place is different, you can't tell the jury what number you're looking for. They can go from anywhere from zero, no causing a case, all the way to millions of dollars. You just throw them in the room and they come up with a verdict. So it is possible. Gene, do you have any thoughts on that?
I have a lot of thoughts. I got to tell you, for Texas, which is hang 'em high, I can't believe they allowed the defendant to plead guilty to a charge where he could academically, theoretically, get probation. And if they're thinking that this is murder, put up or shut up. They should not have allowed him to plead guilty and allow him theoretically to get probation.
Yeah,
that blows my mind.
And that is an excellent defense argument. And the defense did try in certain spots to say, hey, this isn't about him committing a murder. It's about the omission. But Gene, the defense lawyer came out of the box saying, you know what? I'm not going to insult your intelligence and tell you to give him probation. So, that maybe could have been managed a little bit differently. But there's a lot of meat on this bone, guys, and a lot of weird issues with regard to this slow plea case and the commentary that's been made in it. It'll be very interesting to see how fast the jury comes back and what verdict they come back with. But while we wait, we're going to do some business here at the Law and Crime Network. We're going to go to a break. We'll have some great Anne Bremner, Gene Rossi, and fascinating trials on the other end.